Just wait a minute, let everyone get settled. Okay, Mr. Melton.
Thank you, Your Honor. May it please the court. This is an employment retaliation case that's a little bit unusual. It's Title VII retaliation, but it involves post-termination conduct. Most employment cases are we're suing the employer for wrongful termination. What we're suing in this particular case is giving a negative reference to a subsequent employer and causing the termination as a result of retaliation. So Derek Hall worked at UiPath for about a year or so as a VP of sales, and on August 29th, 2019, he made an age discrimination complaint against his supervisor, whose name is Carmel Smith. About 3 weeks later, he was terminated on September 23rd, 2019. Now there's a dispute over the date of termination. The UiPath says it's October 1st. My client says it's September 23rd, but since we're here for purposes of summary judgment, court has to take it into account that my client says it's September 23rd. So sometime shortly after that, he started working for a company called...
So you're saying, in the light most favorable to your client, the time between the protected activity, his complaint, and his termination is about a month?
Less than a month.
But the termination moment isn't the relevant adverse action.
It's not the adverse action that we're complaining about, but it is relevant towards showing circumstantial evidence of retaliatory intent. In other words, we have to show that there's circumstantial evidence that Carmel Smith, when she later on sent the text messages to Accelerate, that she had a retaliatory intent when she did that. And so the fact that there was such a close period of time between the age discrimination complaint against Ms. Smith and the termination by Ms. Smith, that's relevant towards showing a retaliatory intent for the later submitted text.
I'm a little lost. I mean, and this may be a softball question to you, unless I'm misunderstanding, because it's where do we move the goalposts, right? I would agree that the relevant starting date in terms of a prima facie case causal link is the protected activity. That's right. A solid date.
Right.
But I would have thought you'd say, since Smith is the alleged retaliator,
right,
and she says she didn't even know about the protected activity until he was terminated,
right,
I would think the clock would start when she learned about his complaint against her decision, and it would go until the alleged adverse action.
You're right, Your Honor. You make a very good point.
But that's not what you're arguing.
Well, I am arguing that now.
Okay, you're arguing that now. Okay, well, if we go on that theory, and if we go on that, I mean, I don't even know, you can tell me, are you making a pure proximity in time causal link case, or does this have proximity plus other factors?
It has proximity plus other factors. So,
okay, let's just pretend it's just a proximity case,
okay.
And if you want to embrace this view of the chronology, just clarify what the time would be. Did Smith say she didn't even learn about the complaint until after he was fired?
She did say that.
She said that, okay. And then when was that? You would say that's somewhere around September 23rd?
Right, we don't know the exact date because she...
And when did she send the text that on the same day he gets fired?
She sent the text on December 17th.
Okay, so on that theory, do the math. It's October, November, it's about 3 months.
3 months, right.
Okay.
3 to 4 months timing between the protected activity and her sending the text message. And so that is part of what we argued as the causal basis for the retaliatory intent, was the timing of the discrimination complaint and the later sent text messages. I don't think there could be much dispute that there's a fact issue that the text messages themselves led to Mr. Hall's termination from Accelerate. They were sent on the exact same day, and I'm sure the court has read them, but they basically imply that they had a lot of complaints about him, there was a reason why I terminated him, and in the meantime, we don't need this hassle, Nikki. And then the same day, Mr. Hall is terminated. So there's clearly a fact issue that the text messages led to my client's termination. The harder question, and what they're arguing, or they argued on summary judgment and are arguing in the brief, is whether or not that was a causal connection between the original protected activity and the text messages. And
what did your client tell Accelerate why he was fired, why he was terminated?
I don't know if that ever came up, Your Honor. Accelerate and UiPath have a very close working relationship. Right. UiPath is 90% of Accelerate's business. So what my client thought was that going to work for Accelerate made a lot of sense because he already knew what Accelerate needed, and that's basically why they hired him, because they thought, hey, this guy worked for UiPath, he knows what we're doing, he knows the business. So
originally he said, oh, it's obvious I've been retaliated against because I got put on the PIP, but now you've agreed in your briefs that doesn't work chronologically.
Correct.
So the chronology is sort of moving around here.
Yeah, it's a little muzzled, Your Honor. I mean, a little unclear, but
I'm assuming you never made the argument about time being starting when Smith knew. You didn't make that below. So let's go with what presumably you told the district court, which is it's about 4 months, right?
Right, about 4 months.
And then apply the law to that.
Well, then the law says that can be evidence of a prima facie case for causal termination. What the prima facie case law says is that less than 4 months can show a prima facie case for causal termination. Now, the case law kind of goes back and forth on that. There's not really a definite answer from the courts as to whether that's, some say it is, some say it isn't. But what we're saying is that there's not just...
What does our latest published decision on this, January, say?
I believe it said all by itself, it doesn't show a causal connection, if that's the only evidence of causal connection. But in this case, that isn't the only evidence. If I'm thinking of the...
I'm not sure you are, but it doesn't matter.
So, assuming that there's a prima facie case that's made, you didn't present any evidence that UiPath's non-discriminatory explanation was pretextual. Is that right?
That was not argued by the defendant in the trial court as far as summary judgment. They didn't argue.
Right, but the district court found it.
Right, the district court did find without giving us notice that that's what the court was going to do.
And the government defends it on that alternate ground. You didn't file a reply brief.
Well, the evidence that supports the causal connection, in my opinion, also supports the pretext argument. But
where'd you say that in the brief, the principal brief? This is a problem when you don't file a reply brief and then the government, not the government, I'm sorry, the defendant here,
right,
says there's an alternate argument and we have nothing.
Well, I can submit a reply brief, I know, or leave to file it, but I thought it was implicit from my original brief that that's the argument we were making, that the evidence that supports a causal connection also supports pretext. And
but the evidence supporting the causal is overwhelmingly just the time. Are you saying that Ms. Smith was lying when she said her employees said he's harassing us? He's just calling for leads all the time.
There's a fact issue over that. My client denies that he was harassing anybody. And that's what...
Are those calls in the record? Or is
no.
it just your client's declaration against Smith's?
It's basically Ms. Smith says one thing, Mr. Hall says another. That creates a fact issue on whether or not he was making harassing statements. So...
Was he harassing any UiPath employees when
no,
he worked there?
No, and he denies that. He was doing his job for Accelerate, which necessarily involved UiPath employees because the businesses have such a close relationship. But Carmel Smith told Accelerate that he was harassing their employees, and Mr. Hall denies that. So that creates a fact issue. The other evidence, besides the text messages in my client's affidavit, the fact that Accelerate at a party on December 14th said that Mr. Hall is going to be our new VP of sales, announced it to the entire company, and then 3 days later he's fired on the same day that Carmel Smith sends the text messages. So that's a causal connection, and the fact that she stated things that were false also shows a causal connection between retaliatory intent and the termination. I mean, all these cases are almost always circumstantial evidence cases. Nobody comes into the courtroom and says, yeah, I retaliated or I discriminated against. So this is no exception to that. This is a circumstantial evidence case, but as the Supreme Court has said multiple times, when you're talking about intent, especially in employment cases, it's up to the jury, not the courts. Because as long as there's some evidence that shows the intent, which there is in this case, the jury should decide whether or not the text messages by Carmel Smith led to the termination and the text messages by Carmel Smith had retaliatory intent. And unless the court has any questions, I'll...
Well, just still, I mean, on the notion that there's a fact issue that's implicit that you didn't brief, I don't think, tell me am I wrong, is in his declaration, he's not saying, oh, I didn't make those calls. He's saying the opposite. My job required me to make them.
That's correct. Yeah.
Okay, so how does that create a fact issue? Because it may be in his new position, everyone wanted him to call his old employer, but that's not rebutting the claim that the old employer was getting a lot of calls and didn't want them.
Carmel Smith said that he was harassing the employees and also trying to get them to leave UiPath to come to Accelerate, which my client denies. So the fact that Ms. Smith was making false statements to Accelerate, sending text messages that pretty much say fire the guy, and that's what happens, shows a causal connection between what Carmel Smith did and the termination.
Okay. All right, thank you.
Thank you.
Melton, you've saved time for rebuttal. Ms. Fuqua?
Good morning. May it please the court. My name is Kelli Fuqua, and I'm here today on behalf of the appellee in this matter, UiPath. As you have just heard from Mr. Melton, Mr. Hall appeals only the district court's decision to grant summary judgment in UiPath's favor on his ADEA retaliation claim. Now, the district court granted summary judgment in UiPath's favor on alternate bases. The first basis, which we've just discussed at length, is causation. Specifically, the district court found that Mr. Hall failed to establish the requisite causal link between his adverse action and the protected employment activity. Second, because UiPath presented evidence establishing that they had a legitimate non-discriminatory reason for taking the ostensible adverse employment action, which is the text messages, according to the issues that have been briefed. And finally, Mr. Hall failed when the burden shifted back to him to show that that legitimate non-discriminatory reason was pretextual. Now, I think you all have addressed this already. Mr. Hall only addresses this first issue of the causal link in his brief. Therefore, under the law of the circuit, the other issues have been waived. He has not challenged the fact that the district court found that there was a legitimate non-discriminatory reason for UiPath sending the text message. He also has not challenged that the district court found he failed to establish that reason was pretextual. Those issues are waived. I could go sit down. We can all go home. Nonetheless, I will address the fact that the argument regarding the causal link here, because it is what is briefed in Mr. Hall's brief. Specifically, I would like to start out by saying that it is not true that there is a material factual dispute regarding the date of his termination. Mr. Hall states in his declaration that he was terminated on September 23rd. That is the only place in the entire record that that date comes from. Actual evidence, physical documentary evidence, establishes that he was terminated on October 1st, 2019. He signed a severance agreement with UiPath that date. And more importantly, the employment, Mr. Hall's employment extended even further to November 12th, 2019 under that severance agreement because they provided him with garden leave so that he would have the opportunity to have his RSUs with the company vest. So Mr. Hall's employment ends on November 12th, 2019. The evidence also shows, or rather, there's a lack of evidence showing when Ms. Smith actually became aware of the age discrimination complaint made by Mr. Hall. She says that she did not know at the time he was terminated, but that's sort of irrelevant because the negative reference is the adverse employment action here. There's no evidence.
But, I mean, this is the point we're discussing. You would agree then, since she said that she didn't know about the activity that's protected until after terminated, the more you convince us that the termination was effective later in November, that gets it closer and closer to the adverse employment action.
No, I disagree with that, Your Honor. Respectfully, there is zero evidence regarding when Ms. Smith found out.
But we know she said she didn't until after he was terminated.
The question is whether she even knew. There's no evidence that she even knew when she sent the text message, is my point.
Oh, well, then you're down to...
There's nothing. And
okay, did the district court find that? You're saying she never knew that he'd made an age discrimination complaint against her?
I'm saying that the evidence does not show the date on which she became aware of it.
But we know, but I'm saying she herself said, I only found out after termination.
In her declaration and at her deposition, Ms. Smith said that she does not know when she became aware of it. She thinks that it was sometime after that she sent the text messages.
Oh, after she sent the text message, not after employment.
Correct. And I think that this raises an even bigger point here. The burden was on Mr. Hall here to develop the record at the district court in order to establish these facts, that there was a causal link. He had about 12 months to conduct discovery, and there was only one deposition taken of Ms. Smith, and it lasted approximately 36 minutes.
Right.
There was every opportunity to get these facts out of her, and it simply was not done.
Let's say when I looked at the record, I think she did say, in the light most favorable to him, that she did find out, but it wasn't until after he was terminated. And then you would agree the negative adverse action is the post-employment reference, text, correct?
I disagree that the text message, and this was briefed at the lower court, that the text message itself constitutes a negative reference, but the district court did resolve that close question in favor of saying.
Yeah, and in your brief, you didn't say that it didn't.
Not on appeal, no.
Okay. So then we got a pretty close proximity if we're looking at our published law, cases like Evans in January.
I disagree because, again, the date, there is no date. There's no date.
Well, I'm asking you to assume that I think the record in the light most favorable shows that she, the one who got him fired, same day she wrote the text, found out that he'd complained against her, age discrimination, after. So I'm asking you to apply cases like Evans in January. If those facts are true, would you agree that case law says it's close enough for a prima facie case on causation?
Is the hypothesis or the hypothetical question that she found out on October 1st, 2019 then?
No, I'm just saying she found out after his termination, whether it's October 1st or as you've argued that it wasn't until November 12th. Either one. Under Evans in January, that would at least get you through a prima facie case of causation. Yes or no? Those cases.
I disagree, and I would say that the termination decision was made on...
No, I'm asking you to discuss Evans in January and tell us what they say about length of time.
I am not aware of what Evans said in January, but I do know that...
No, Evans is one case. January cited Evans again. They're both public.
I see. Okay, so Besser is the decision that the district court relied on to talk about temporal proximity. And in Besser, the court discussed Evans and said that essentially the Evans decision was decided based on its discussion of district court decisions within the Fifth Circuit, and that it clarified Evans and said that temporal proximity of, I think it was 2.5 months alone, is not enough to get you there. And in Evans, more importantly, the issue, I think, ultimately turned on a time frame of like 5 days, and that is not this case.
And you're not familiar with January, the case?
I am not, no, Your Honor.
Go ahead.
So again, talking about the causation here, the temporal proximity alone does not get, Mr. Hall over the threshold. Now, you heard that Mr. Melton said there is also additional evidence that sort of pushes him over the threshold, this circumstantial evidence. The district court again considered this circumstantial evidence and decided that it did not. And that is, again, because the record does not support any of the circumstantial evidence. The first piece of circumstantial evidence that Mr. Hall discussed in terms of causation was that Ms. Smith placed him on the performance improvement plan after he filed his internal age discrimination complaint at UiPath. Now again, the only basis that Mr. Hall relies on is his own declaration. The actual evidence, including emails, shows that he was placed on the performance improvement plan before he filed the age discrimination complaint. At his deposition, Mr. Hall said, "I went to HR afterwards to say that I think the PIP was because of my age." That doesn't get him there. The next piece of circumstantial evidence was that the PIP contained impossible goals. Again, the district court properly addressed this and decided that Mr. Hall produced no evidence that the PIP contained impossible goals. There was no evidence showing, for example, that the goals were difficult to meet. They were just the duties that had been lined up for him in his job, and he knew of those duties and he failed to meet them. Finally, the last piece of circumstantial evidence that Mr. Hall relies on is that Ms. Smith terminated his employment before the PIP concluded. Again, this is nowhere in the record, and the actual evidentiary record shows that this was not the case. As we've already discussed, the termination decision was conveyed to Mr. Hall on October 1st, 2019, not on September 23rd, I think is the date that he's thrown out here. Based on this fact, causation is, Mr. Hall fails to establish the requisite causation, and the inquiry ends here. If you assume that he meets the prima facie case, and we move the burden over to UiPath to establish the legitimate non-discriminatory reason, the district court again properly concluded that UiPath did, and I will reiterate, this issue has been waived by Mr. Hall on appeal. The legitimate non-discriminatory reason here, as the district court discussed properly, was that Mr. Hall was contacting his old colleagues at UiPath. I am not aware of any record evidence or any claim that Mr. Hall was trying to get them to leave their employment. I don't think that's relevant at all, but I would like to state that for the record. In addition, he does, as Your Honor pointed out, admit that he was contacting his old colleagues because that was the very purpose of his job. Moreover, there was evidence that one of the reasons he was terminated by UiPath was because he persistently contacted clients at UiPath, and Ms. Smith even had to take him off of those clients because those clients didn't like the way he kept pestering them. So it's not surprising then, and there's no reason to believe that it's false, for example, that he was doing the same thing again because his very job was to contact UiPath employees in order to get their business.
Your first point is just it's not preserved, end of story. But if we were to get into it, does the record contain the complaints from his old colleagues complaining to Smith saying, stop this guy, or is it just her declaration against his?
There's her declaration in addition to her deposition testimony, and I believe in her deposition testimony she discusses that these were verbal conversations.
So there's no record.
There's no email, for example, from Mark Waldheim saying that.
So it's her word that they were complaining. And does he, when I go back to it, does he say, no, I wasn't?
He admits that he was contacting his old colleagues. That is the evidence in the case. Moving on, finally, to the element of pretext. Again, this issue has been waived on appeal. So this is yet another basis for this court to affirm the district court's summary judgment decision because it has been waived. Nonetheless, if the court decides to look at this issue for its merits, the evidence does not show that the reason was pretextual, because the fact remains that there is nothing in the evidentiary record rebutting UiPath's Ms. Smith's reason for texting Ms. Schaefer, which is what we just discussed. He was contacting his old colleagues. Ms. Smith texted Ms. Schaefer and said, I would prefer that he not cover my territory. Let's discuss it sometime in the future. They didn't discuss it any further. Now, unless Your Honors have any further questions, which I'm happy to clarify, that will rest my case.
All right, thank you, Ms. Fuqua. Mr. Melton for rebuttal.
Thank you, Your Honor. one of the things that counsel said was that it was our burden to show what happened. Well, that's our burden at trial. This is summary judgment. They're the ones who have the burden of showing that there is no genuine dispute as to any material fact. Obviously, a material fact in this case is, when did Ms. Smith know about the discrimination complaint? Could it have been even on December 17th, the day that she sent the text messages? They didn't present any evidence as to when Ms. Smith found out about this. And for purposes of summary judgment, that's their burden to show that. And what I believe is that a jury can infer from the fact, I mean, when somebody makes an age discrimination complaint against you, it seems like you would remember when that was. Well, she claims she doesn't. Doesn't give a date, says, I don't know when it was. I don't know when I found out about it. I just know it was after I terminated him. Well, when a jury hears that, they can say, wait a second, how does she not know that? And why is she not telling us this date? And from that, you could infer that she found out the day she sent the text messages. Or a reasonable jury could.
What's the company policy for advising someone if a discrimination suit has been filed against you? Is that always made known immediately, or does it work itself out?
Well, I'm not sure what the policy is, but apparently, according to them, they didn't tell her that there was a complaint. All they said is that Mr. Hall made a complaint against Ms. Smith, and we investigated it, and we didn't find any discrimination. Their story is that Ms. Smith didn't know about the discrimination complaint until after the termination, the first initial termination from UiPath. And they have the burden on summary judgment of proving no genuine issue of material fact. That is a key fact in this case, and they haven't told anybody what it is. And if it was December the 17th, if a jury can infer that, then that all by itself shows both causation and pretext, because it happened the same day, not 3 months, 4 months, or any other time period. So, because they have the burden on summary judgment, I believe that the court should reverse the trial court's decision. If the court has any questions, I'm through.
All right, thank you, Mr. Melton. Your case is under submission.
Thank you.
And the court will take a brief recess before hearing the final two cases.